Have you ever wondered what makes a good lawsuit, or how an attorney analyzes a particular set of facts to determine whether or not you have a claim worth pursuing? Hi, my name is Peter Lamont, and I'm a business and personal law attorney practicing here in the state of New Jersey. Today I want to give you some insight into how an attorney analyzes a claim and decides whether it makes a good lawsuit. Well, here's how it works. Every lawsuit is comprised of two essential elements, and it doesn't make a difference whether we're talking about a personal injury lawsuit or a breach of contract lawsuit. Every lawsuit must have A, liability, and B, damages. So, as a plaintiff, you need to establish liability, which is essentially fault, and then you must establish that you have suffered some sort of tangible damages. In other words, property damage, personal injury, or some sort of monetary damage. There are other sorts of damages, but those are essentially the main ones. So every lawsuit's got to establish both liability and damages. Now, there are times when you've got liability in your favor, but you don't have damages. You don't have a good lawsuit. And vice versa. If you can establish damages, but you can't establish liability, you also don't have a good lawsuit. So an attorney, when he hears your set of facts, quickly analyzes, is there liability in your favor? Was somebody at fault for what happened to you? And if so, can you establish some sort of injury as a result? Because if you have both, you may have a good claim. If you don't have either, or you only have one, then you don't have a good claim. Now let's apply this to the real world. Let's assume for a second that you're walking down your street, walking your dog after a snowstorm, and your neighbor has shoveled his walkway and he's thrown down some ice melt, but overnight the ice melted, refroze, and now it's a little slick. So as you're walking with your dog, you slip and fall, and you unfortunately fracture a vertebrae. You're taken to the hospital, you're put in traction, so it's a pretty serious injury. So you go to your lawyer and you say, listen, I've got a serious injury. Clearly I have got damages established. I want to sue this guy. He didn't maintain his property the way he was supposed to. So the attorney looks to see if there's liability. Now, there's no ordinance that requires him, the landowner, to do anything except remove the snow within a reasonable amount of time after a storm. And he did that. So the attorney may say, well, there's no case law or there's no statute, and clearly there's no ordinance that requires your neighbor to do anything beyond what he did. So although you've got this horrific injury, you can't establish liability, and therefore the attorney may say to you, I'm sorry, it's not a good case. Now, conversely, let's say the same thing happens, except you're walking in front of a business. Now, in New Jersey, business owners have a non-delegable duty to maintain their property in a safe condition. So it goes beyond what your neighbor might be responsible of doing, which is remove the snow within a reasonable amount of time after a snowfall. But a business is held to a higher standard. So same set of facts, you're walking down the street, you slip and fall in front of a restaurant, and you suffer the same injury. Now, you go to the lawyer and he says, well, wait a minute. It's a business, a commercial entity, and they've got a duty to maintain their property in a safe condition. Clearly, it wasn't safe. You slipped and fell. So the attorney in that set of circumstances may believe that he can establish liability. And again, you've got damages, so he may take that case. Let's do one more example. You're walking in front of that same restaurant. They haven't shoveled at all. It's an ice rink. You slip and you fall. Fortunately, you were wearing a very heavy jacket, and when you fell, you were kind of cushioned. You didn't hit your head. You didn't break any bones. You don't really have an injury. You were embarrassed. Everybody saw you and they laughed. You were sore. Maybe you had to, stay home from work the next day. So you go to your lawyer and you say, listen, The guy didn't shovel at all. I slipped and fell. And he says to you, all right, what are your injuries? And you say, well, I was embarrassed. And, I took the day off because I just felt sore. Most likely, the attorney's going to say to you, well, yeah, you've got liability, but you can't establish damages. At least not damages that are recoverable. And so he may refuse to take the case. So why do I share this information with you? Well, I do so because I want you to develop a better understanding of the legal process and how an attorney analyzes a claim. If you have a claim and you're trying to determine whether or not you can establish both liability and damages, I encourage you to call me. I'll answer your legal questions. I answer questions like yours on a daily basis, and I'd be happy to discuss your situation with you. You can reach me at 973-949-3770 or via email at plamont, that's Lamont, at peterlamontesq.com. Thank you again for joining me. I'm Peter Lamont.